Imagine you're riding a vehicle home after a gathering. Suddenly, you're stopped at a poorly lit checkpoint. The police tell you to step out, they go through all your belongings, and the next thing you know, you're being arrested. And why? Well, all because an anonymous informant told them to do it. It begs a really massive question about our civil liberties. Can a single unverified tip actually give police the ultimate right to just bypass the Constitution and conduct a warrantless search of a moving vehicle?
So, welcome to this explainer. Today, we're going to meticulously dissect a real landmark ruling from the Supreme Court of the Philippines. It's the case of Evardo versus People. And honestly, this case provides an absolutely fascinating look at the delicate boundary between law enforcement power and your constitutional rights as an ordinary citizen. We are going to break down exactly how the highest court evaluates the legality of a police search using the direct facts from this historic decision.
Here is our game plan for today. We'll quickly run through the checkpoint apprehension, the rule on warrantless searches, the solitary tip doctrine, deconstructing police suspicion, the fruit of the poisonous tree principle, and finally, the Supreme Court's verdict.
Let's start with Section 1, the checkpoint apprehension.
Okay, let's establish the facts from the night Virgilio Evardo and Justo Algazo were arrested in Bohol. The timeline here moves incredibly fast. According to the prosecution, a police superintendent received a tip from an asset right around 6:30 p.m. claiming two suspected drug dealers would be traveling down the highway. By 8:30 p.m., literally just 2 hours later, the police team had already set up a checkpoint. Now, interestingly, an officer actually testified that this checkpoint was set up in a spot with very poor lighting. We're talking illuminated by nothing more than a light coming from the corner of a nearby house. And shortly after setting this up, they flagged down a tricycle carrying the two men in its sidecar. Now, when that tricycle stopped, the police officers jumped straight into an immediate, extensive search, completely without a warrant. So how on earth did they justify this? Well, the officers testified that the suspects were already on a police drug watch list and had been the subject of prior surveillance. They also claimed that when they flagged the tricycle down, Evardo and Algazo looked pale and were visibly trembling. On top of that, one officer alleged he saw Algazo place something into the rolled-up rain cover or the terrapal of the sidecar. Based on this, the police searched the rain cover, the suspects' wallets, and even their underwear. Ultimately, they recovered sachets of what tested positive as shabu or methamphetamine hydrochloride.
Moving on to Section 2, Rule on Warrantless Searches.
To really understand the immense legal battle here, we have to zoom out and look at the 1987 Philippine Constitution. It generally requires a judge to personally determine probable cause and issue a warrant before any search can happen. But, the law recognizes that there are certain practical exceptions to this rule. Things like a search incidental to a lawful arrest, items left in plain view, a consented search, a quick stop and frisk, and, crucially for this case, the search of a moving vehicle. The lower courts actually used this specific moving vehicle exception to initially validate the search and convict Evardo.
But here's the absolute kicker. Even when applying these exceptions, like searching a moving vehicle, law enforcement officers don't just have unbridled do-whatever-they-want discretion. A warrantless search of a vehicle absolutely unequivocally requires probable cause before an extensive search can legally begin. And the Supreme Court defines probable cause as a reasonable ground of suspicion, supported by circumstances sufficiently strong in themselves to warn a cautious man to believe the accused is guilty. Basically, it requires way more than just a gut feeling or a hunch.
Which brings us to Section 3. The solitary tip doctrine.
So, this is the multi-million-dollar legal question. Can an unverified tip from an anonymous asset all on its own create that necessary probable cause to search a moving vehicle? Drawing heavily on some massive precedents from cases like People v. Janssen and People v. Sapla, the court firmly answered absolutely not. The court explicitly noted that bare suspicion is never enough. They reinforced the doctrine that a solitary tip hardly suffices as probable cause for an extensive, highly intrusive warrantless search. I mean, think about it. To rule otherwise would set an extremely dangerous precedent. Literally anyone could hide behind anonymity, send in a false tip, and subject innocent citizens to severe privacy violations.
To make an exceptional warrantless search valid, the court ruled there has to be a confluence of several independently suspicious circumstances, and this is vital. These circumstances must happen prior to the search commencing. You definitely cannot use what you happen to find during the search to justify the fact that you started the search in the first place. That's just not how it works. Next up, Section 4, Deconstructing Police Suspicion.
Now, the police tried to argue that they had way more than just a single tip. They claimed Evardo and Algazo were on a watch list and were clearly acting suspiciously. But the Supreme Court completely dismantled this narrative. They just tore it apart.
The court noted that pointing out the suspects were on a drug watch list actually backfired and damaged the prosecution's case. Why? Because it just proved the police officers were heavily biased and predisposed to see guilt from the get-go. They had specifically targeted these two men. In fact, one of the officers even admitted they had previously tried to get a search warrant for these exact men, but ended up abandoning the effort. So they knew exactly who they were looking for when that tricycle pulled up, and that completely tainted their perception of everything that unfolded next.
It forces us to take a step back and ask, were these actions actually genuinely suspicious? The court pointed out that looking pale and trembling when you are suddenly confronted by armed police officers at a really dark checkpoint, remember, illuminated by just a flashlight and a single house light, is an entirely natural reaction for an innocent person. The police were pretty much just seeing what they wanted to see. Furthermore, any alleged attempt to flee or hide something only happened after the police had already initiated the illicit search by forcing the men out of the vehicle, meaning, logically, it couldn't possibly serve as the probable cause to start the search.
That leads us right into Section 5, Fruit of the Poisonous Tree.
Because the officers lacked objective probable cause prior to the search, the entire case faced a massive constitutional domino effect. Here's how it plays out. Step 1, the initial search is declared invalid. Step 2, because that search was unconstitutional, anything found during it, the so-called fruit, becomes completely legally inadmissible in court. Step 3, in drug cases, the confiscated drugs are the corpus delicti. That's the essential physical proof of the crime. So if the drugs are inadmissible, you suddenly have zero proof of a crime. Which brings us to Step 4. Without proof, the only legally possible outcome is an inexhaustible acquittal.
And listen, this isn't just some clever legal loophole. The 1987 Constitution explicitly mandates this right in Article 3, Section 3.2. It clearly states that any evidence obtained in violation of the right against unreasonable searches and seizures shall be inadmissible for any purpose in any proceeding whatsoever. The evidence is fundamentally tainted. It is completely 100% placed beyond the court's contemplation.
Finally, Section 6, the Supreme Court verdict. Applying all of these very strict constitutional standards, the Supreme Court completely reversed the decisions of the lower courts, who, by the way, had previously trusted the police narrative, and they fully acquitted Virgilio, Evardo, and Lopena. By ruling the search illegal and the evidence inadmissible, the prosecution was left with a fatal handicap. They were essentially insisting a crime was committed but possessed absolutely no valid evidence to prove it. The court powerfully reaffirmed that constitutional rights cannot be hollowed out by targeted policing and unverified tips. Deep within its ruling, the court issued a really profound warning. Quoting heavily from past precedent, they stated, "The citizen's sanctified and heavily protected right against unreasonable search and seizure will be at the mercy of phony tips. The right against unreasonable searches and seizures will be rendered hollow and meaningless. The court cannot sanction such erosion of the Bill of Rights." It's an incredibly powerful reminder of why these strict procedures exist in the first place. Which leaves us with this final, truly provocative thought to consider. Yes, the Supreme Court stepped in here, but it highlights a pretty terrifying hypothetical. If your constitutional protections could be effortlessly bypassed by an anonymous tip and a highly subjective police watch list, how secure are your civil liberties today? It really underscores the immense, ongoing importance of maintaining that incredibly delicate balance between empowering law enforcement to do their jobs effectively and rigidly protecting the civil liberties of every single citizen. Thanks so much for diving into this incredibly important legal explanator with me today.